Good afternoon, this is Sean Golding with Golding & Golding, here to discuss the basics of what you do when you get an FBAR penalty, pre-assessed, post-assessed, do you have an appeals right, can you go to court, how do you litigate, how do you dispute it, how do you get out of this mess, right? So the FBAR penalties, they're a lot more common. FBAR has been around since 1970, give or take. Enforcement was taken over by the IRS in 2003. Penalties for non-compliance with foreign account reporting, and it's on the rise. I mean, it's definitely a priority, especially with the introduction of FATCA. Enhanced reporting compliance is definitely a mainstay. And so generally the reason why people will get into problems with the FBAR is because they missed the due date, they filed it late, they filed it incomplete, just didn't do a bang-up job on it. There's penalties that will be either civil, and civil penalties will be willful or non-willful. There's also criminal penalties, and we'll get to in a second. Most of the time, penalties are going to be civil. And then in the realm of civil penalties, most of the time they're going to be non-willful. Sometimes people do get hit with willfulness penalties. Those penalties can be pretty exorbitant, so the idea is to try to stay away from that. The problem is, in order to prove willfulness, the IRS or the U.S. government, if it's litigation, doesn't need to show that there was any intent. There's things like reckless disregard and willful blindness, which significantly lower the standard that they have to meet in order to show that someone was willful. Criminal is even more rare than willful. Civil penalties, generally criminal penalties, arise in situations in which someone's in trouble for something else. Money laundering, tax evasion, structuring, smurfing, things like that. Not because Joe has a few accounts overseas, never heard of the FBAR, no idea what FinCEN means, why he has to file the form. Okay. Letter 3709 is what happens when you get that notice of the idea or pre-assessment that the IRS wants to issue the penalties. Okay, with the pre-assessment, that's the best time to kind of jump in there and try to fight it. The taxpayer has 30 days to respond, and in that time they can request it go to the IRS Office of Appeals. I say taxpayer hesitantly because you don't have to actually file a tax return in order to have to move forward and be required to file the FBAR. In fact, it's U.S. persons, U.S. citizens, legal permanent residents, foreign nationals who meet the substantial presence test, trusts, entities, etc., etc. So the idea that you don't file a tax return has nothing to do with the FBAR. That's where a lot of people get tripped up. The IRS Office of Appeals is an independent office, as much as you want to believe that it's an independent office, right? But they will take a look at it and decide. Sometimes you get kicked back, then you get another opportunity to try to fight it, right? But let's just say it doesn't work out in your favor at the Office of Appeals. Then down the line, you'll get an enforcement notice, different letter, different enforcement process. Now there's an assessed penalty, okay? Here's where the problem is. It's not a tax, so you can't go to tax court. You can't, you don't the notice of deficiency or whatnot, your nod letter, 90, 150 days. It doesn't happen like that. For FBAR is Title 31, Money and Finance, not Title 26, Internal Revenue Code. The only reason why the IRS has anything to do with the FBAR is because they enforce the penalties. Okay, so if it gets to the point that you don't pay, then a lawsuit will probably be filed by the U.S. government. Get a chance to defend yourself, right? If they're saying it's willful, you could say it's non-willful or that you have reasonable cause, and reasonable cause is normally sufficient in order to avoid the penalties. Otherwise, you can say, heck with it, you're going to pay the penalty and then go through the refund process and sue for refund. Then you're on the offensive, which is good, but you have to pay the penalty up front, which is bad. The reason why people prefer tax court is because you don't have to pay anything until the process is complete. If you're worried about getting FBAR penalties, if you think something may be coming, maybe you got a soft letter, you may want to consider getting into compliance. There's various programs available to assist you with that. They're called Offshore Voluntary disclosure programs, voluntary disclosure programs, tax amnesty, etc., etc. VDP, the Voluntary Disclosure Program, is for both domestic and offshore, and it's for people who are either willful or can't certify under penalty of perjury that they're not willful, okay, or non-willful. There's things like reasonable cause and streamlined if you're non-willful. You can also do delinquency procedures as an alternative. We have tons of free information available on our websites. You can always reach out and schedule a reduced fee initial consultation if you think it's appropriate. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.